Welcome back to another episode of the Canadian Immigration Podcast. I'm your host, Mark Holthe, and I'm here with my guest, Igor Kyryliuk. How you doing, Igor?
I'm doing well, Mark. Thank you for inviting me to appear for this episode.
Well, you're back by popular demand once again after drafting a pretty awesome blog post. And this is going to form the basis of our episode today within our Time's Up series. And this is all about humanitarian and compassionate applications. And if you are just watching this video or listening to it on our podcast waves, absolutely do not stop at this. Make sure you head over to the Holthe Law website, go to our blog post section, and Igor has a phenomenal blog that I want to share with you here. It is entitled H&C or Humanitarian and Compassionate Applications, a Lifeline for Those Without Options. And this is a super comprehensive, everything that you would ever want to know about preparing and submitting a humanitarian compassionate application. There's tips, there's strategies, there's insight into what officers are looking for, and that is what we are going to be discussing today. So to this stage, we have covered the realities of this change and this shift in immigration policy that the Liberal government has put in place, all designed to reduce the number of temporary residents in Canada. And many people, in fact, they're projecting up to as many as 1 million temporary residents they are hoping will simply go home. And when your work permit expires, we've covered that topic as to your options. And within that first episode that we did of our Time's Up series, we mentioned that there are pathways that people are looking at. And one of the pathways, when all else fails, is the humanitarian and compassion application. In future episodes, we will cover the refugee process, but we're seeing a lot of people right now, Igor, who are thinking, hey, I'm going to file a humanitarian and compassion application because I'm just not eligible or I don't have a pathway through one of the economic PR streams. And these really are directed to, the Time's Up series is directed to all of you post-grad work permit holders or individuals on work permits right now who were hoping that there would be a pathway to permanent residence through the Canadian Experience class or through a whole host of other, PNP programs. And the reality is right now, there just are not options. So people are, we've seen a lot of reports in the news. The Prime Minister just came out over the weekend talking about bad actors that have contributed to the problems that we're seeing within the immigration program. And sometimes I wish the Liberal government would, do a little bit of a better job acknowledging their role in this process. But ultimately, they're doing what they need to do, at least in their mind, to try to reach, to reach this level of reducing the permanent residents that, well, they've reduced the permanent resident numbers, but to reduce the number of temporary residents in Canada. And so we'll see how it all plays out. But many of you are thinking, well, what the heck is a humanitarian and compassionate application? What is this H&C that everybody's talking about? And in our episode today, this is exactly what we are going to share. So, Igor, if you were to kind of summarize, in terms of introducing the topic, what would be really a short little elevator pitch for what an H&C application is?
Yeah, H&C is an exceptional application that is approved only in exceptional situations. And it doesn't have to be exceptional to a point where you have to pass a certain threshold, but it's I would advise that you think about H&C applications as a last resort measure that you utilize only if you have circumstances that would compel a reasonable, fair-minded person to somehow relieve your misfortunes. And we will be coming back to the tests where we will quote the exact test from few federal court cases as to what is the threshold. Again, and we keep coming back to this word threshold, but how complicated your circumstances might be when before the application can get approved. So one problem that I see right now, and again, being Ukrainian, I cannot stop talking about Ukrainians. Many people, especially from Ukrainian background, they talk about H&C as humanitarian program. Well, this is not a program. That's first. H&C is not another pathway to permanent residence. It's not a loophole. It's not a backdoor to get your permanent residence. It's an application that allows the minister to make an exception and grant you permanent residence, but only in some events, in some circumstances where this would be absolutely necessary, and it would be not humane not to give you permanent residence.
And, just to take this a little bit further, Section 25 of the Immigration Refugee Protection Act is the foundation for this. But, to kind of put it into layman's terms, this application is really, your situation has to be of such a nature that, the average person, the average Canadian, if they looked at your situation, they would feel compassion for you. And they would feel, wow, this is really tough, and really this individual shouldn't have to go home and then suffer whatever they're going to suffer, or face whatever hardship they may face. Or, it just pulls on the heartstrings to the extent that a reasonable person would want to relieve that suffering, that misfortune that you faced. And so please, whatever you guys do not buy into this concept that you can use this H&C as a backdoor to stay in Canada, when you really don't have anything involved in your life that would be of such a nature to create a hardship. And that's really what we're going to drive forward as we cover various sections within the H&C process. So when an officer is processing these applications, Igor, what are they actually looking at? What are the factors that are considered in the context of an H&C?
Yeah, so when the officer looks at the application, they want to see that the person endured or will endure some hardship. And this hardship, we have 3 words that describe hardship, right? And those words come from the case of Kanthasamy. So the words unusual and undeserved or disproportionate hardship. So that was the test. This test was a little bit modified, and since 2015, the court clarified that you don't want to use those 3 descriptors, unusual, undeserved, and disproportionate hardship, as a rigid test, right? So it's not like a checklist. Is your hardship unusual? Is your hardship undeserved? And so on. Instead, the officers must look at all of the circumstances. Holistically, all circumstances must be considered together. There is not a single factor that would push the case over the threshold, or it's essentially the officer looks at everything all together in determining whether you actually have undergone hardship or will endure hardship. And so when assessing hardship, the court again refers the officers to the CHIRWA framework, which is another case from the federal court, where the officer are instructed to assess whether, having regard, and this is a quote, having regard to all of the circumstances, including the exceptional nature of the H&C relief, the applicant has demonstrated, and this is very important, right? So that decent, fair-minded Canadians would find it simply unacceptable to deny the relief sought. So essentially, the gravity of your situation, the hardship that you endured or will endure, must be such that just a reasonable person would think this is not fair for this person to go through this. And in assessing this whole situation, the officer essentially looks at different factors, and RCC website provides us with a list of factors, but this list is not exhaustive, right? And so it includes establishment in Canada, ties to Canada, best interest of the child, factors in the country of origin, health considerations, family violence, consequences of family separation, establishment in Canada due to the inability to leave, and ability to establish in Canada if the client is applying from the overseas. And then the last factor that RCC lists on their website is any unique circumstances that might merit relief. So this opens the list to other factors. And essentially, it brings me back to the main point. The officer looks at everything. They consider every single evidence that you submit. And by assessing your whole life, the officer will decide whether it's going to be not fine if they would send you back home. Like if you read the story of a person and you have this lump in your throat, that's a good signal that maybe there is a case to make.
Mm-hmm. Yeah. Okay, well, we've got a number of factors there, and you can go to the blog post, you guys. You can read Igor's blog post that was just released November 19th, just yesterday, and we're recording this on November the 20th, 2024. Go take a look at that blog post because it goes into depth, each of the factors. But I want to just talk about some of the key ones today, Igor, and just flush out a little bit of detail and provide some examples to people, because sometimes it helps to understand if you can see how it was utilized in previous situations. And if you're listening to this episode and your situation starts to resonate with one of the stories or examples that we're sharing, well, in those circumstances, then an H&C application may be right for you. But one of the things I'll lay out there right from the beginning is that these are not a simple application that you just fill out a form and submit it. It requires an enormous amount of effort to do it right and to really put together an application that will give you the best chance of success. We always start with an immigration consultation with clients who want us to assist in filing an H&C application, because in that consult we can get an idea as to your unique circumstances and whether or not they could meet some of these, have enough evidence to meet and demonstrate some of the factors that an officer is looking at before they decide to approve. So let's start right off the bat, Igor, with probably the single most important factor, and that's the best interest of the child or a child within the application. And this requirement is actually baked right into the legislative provision itself, isn't it?
Yeah. So best interest of the child is one of the factors that is specifically mentioned in the legislation, unlike any other factors. And the reason why is that if you think about it, not a single child deserves to go through hardship. Children have to enjoy their childhood without any worry for their security, for their well-being, for whether they will have food on the table for tonight or not. So children are always this paramount point of attention, right? So the court always looks at, will the decision impact any child? And by referring to any child, it's important to know that, and many people get this wrong. So they think, if I don't have a child, then best interest of the child does not apply to my situation. So the court will just ignore whatever child out there. In fact, the court looks at the interest of the children, not only your children, your own children, but children in your family or children that you directly help or assist. For example, you may be babysitting someone, or maybe you assist financially a family who has a child, and you are the only provider for the child. And that child does not necessarily have to be in Canada. So there is a ton of different cases talking about different situations involving children, but they all come to the main point. The child must be either in Canada or outside Canada. It can be your own child or it can be someone else's child. And the decision, if the decision applies to you, and let's say you are forced to leave Canada, and that relocation out of Canada will impact the ability to provide for the child or the ability to care for that child, that affects the child as well. So
you bet.
So the court is really alive to all of the children who might be
Yeah.
affected, even indirectly.
Yeah. Okay, I'll share an example for the listeners. So, many of you will remember back in, I guess it was 2021, they created the TR to PR pathway. And there was over 90,000, I think 96, 97,000 people that actually applied through that program to be able to transition from work status or student status to PR in Canada. It was a one-time program, one-time shot based on humanitarian and compassionate. It was issued as a humanitarian program. And in that case, it actually was a program. So there were requirements that you had to meet, and it was a race to file. It was a crazy time in our firm. We had created a course. We did a whole bunch of things to help people. And it took them quite a while to process these applications. And the more difficult ones got pushed later and later. And so it wasn't until probably the second year that individuals started to get refusals. And one individual who booked a consult with us, she's from the Philippines, her application was refused because she studied in a school that did not issue DLIs, did not issue post-grad work permits. And so she'd studied at a school, then she got an LMIA-based job offer with a company. And when she submitted her application, she didn't realize that because she had not graduated from a DLI that issued, like a post-secondary institution that issued post-grad work permits, she was ineligible to apply through her program. And so she got a fairness letter from IRCC, and she happened to reach out to me, and we chatted about it. And as I dug more into her story, I started to realize that she had two sisters with their extended family in the Philippines who lived in fairly humble circumstances, and they had a number of children, school-age children. And she was sending money home to them. And because of the money that she was sending home to them, they were able to go to school and attend a good school. They were able to have health coverage and things that they would not have otherwise been able to obtain, because essentially the families lived on a farm and they raised crops and they sold them, but it was a small little farm. And without that money, those children would have suffered. They would have not had the opportunities that they had because their aunt was in Canada working and sending money home. So that was a real important factor in our H&C application that we decided to make. So, and this is kind of a lesson too. At times, even within some economic applications, depending upon the circumstances and the program, sometimes you can make humanitarian compassionate arguments within that application. And that's what we did in response to this procedural fairness letter. We sent back all of these factors, and really, for all intents and purposes, Igor, it was like an H&C submission in the context of a response to a procedural fairness letter, because we couldn't say, well, no, actually, the school was, issuing post-grad work permits, because it wasn't, right? Factually, she did not meet the requirements for the program. And so we sent the submission in, and then the application was moved and triaged over to an H&C application. And they triggered the issuance of H&C forms, and we went through the process. But we provided a ton of evidence to support it. We provided, evidence that she was submitting money, sending money back to them. We even had the whole family take a picture with all the kids in their school uniforms and everything, and included that within the application, as well as a bunch of other things that we included. But that was just an example of where the best interest of the child was accepted by the officer, and obviously there were other factors as well, but in the end that H&C application was approved, and I was very, very happy, and the client obviously was ecstatic, because without that she would have had to go home. So that's the example. Now let's shift gears, Igor. Let's talk about hardship, because that's thrown out there a lot. Like, what the heck does hardship even mean?
Yeah. So as we've discussed briefly, hardship is not this rigid test, right? Again, we come back to the three descriptors: unusual, undeserved, and disproportionate hardship. So that is not a strict test anymore. And essentially, hardship is assessed through your individual circumstances that just are not acceptable to fair-minded Canadians. And again, by looking at different factors, the officer makes their own discretionary decision whether they believe you deserve to remain in Canada, and it would be not fair, not humane to send you back home. So in assessing all of this, the officer looks at a myriad of circumstances that surround your situation, like your emotional, psychological impact of the relocation, of the removal from Canada, physical or financial difficulties. Everything is considered in this assessment of hardship.
And I know in the past, one of the factors in that one example that I'd given you, which we use in many other H&C applications, is country conditions, right? What are the circumstances in the country that the person is going to have to go back to? And how does that play into hardship? So country conditions, sometimes health is an issue. We had another client, didn't we, Igor, that was transitioning, in the middle of transitioning, from like gender-wise, and they just would not be able to. It would have been a horrible situation to be partway through that transition, and then have to go home where there just wasn't that same level of care. And then, of course, in addition to health, is one of the pillars is family separation. So I had another example of an H&C where the father was a foreign national, the children were Canadian, and there was a really challenging breakup between the husband and wife, and the wife just really fell off the deep end. She had substance abuse, problems, depression, mental problems, and she just literally could not take care of the kids. Well, the husband tried to stay. His work permit ran out, transitioned to a visitor record, and in the end, they refused the visitor record. And so there's, we also have talked briefly about temporary resident permits and work permits. And so in that case, we were able to get a temporary resident permit and an open work permit as a result of the hardship and all of the problems that he had, because he had to provide for his children, and he was their sole caregiver. The mother was literally off, she was unable, and they were separated and in the process of getting divorced. And so it would have caused tremendous harm. So it was a melding of best interest of the child, hardship, a bunch of things. And he was, we're also going to get into establishment here in a second, but there's a number of factors we're able to point to. But family separation was a huge one. So if he had to go back to Mexico, then those children would not have had someone to care for them. They probably would have had to go into some form of, foster programs. And so hardship, that's,
And Mark, maybe what we can also mention here is that people don't have to look at those factors, again, as a checklist, right? Like, do I have the factor of best interest of the child? Check. Do I have the factor of adverse country conditions? Check. The reason why is that because sometimes your circumstances don't fall straight, like square into a specific factor. Sometimes they can be split in between a couple of factors. So a couple of factors may be in play when you describe your circumstances. A good example would be if, let's say, you have a child who's a Canadian citizen, and you have to relocate to a country where medical treatment is not available. So all three factors play in this scenario, right? So best interest of the child is not to get relocated to a country where the child isn't able to access healthcare. Healthcare now becomes a standalone factor here. Like, perhaps that would be not humane for you to live in a country where you cannot continue your treatment, or where you will not be able to access healthcare should this treatment be necessary. And then adverse country condition is, for example, corruption that prevents the development of healthcare, or maybe there is a war, right? So, for example, in my home country, in Ukraine, we have an active warfare. And because of that adverse country condition, healthcare is not available to many people. And because of the war, children are in danger. So all factors kind of play in tandem all together. And the point of us working with the client, like how we assess the situation, again, it's this lump in the throat kind of test. And when you start talking with the client and they start sharing their story, you kind of pull this thread, and you start asking them the right questions to collect the information that would be necessary for you to make a pitch for as many factors as possible. Again, you don't want to over exaggerate. You want to present the information as it is accurately. But if there is indeed some danger, some threat that the client or the children would not have the benefit of the security and stability of life as they have in Canada, back in their home country, then we want to explain everything that is in play.
Yeah, absolutely. So best interest of the child, hardship. Now let's talk about establishment in Canada. So what do they look at? What do they mean by establishment? Is it a temporal, purely a temporal? Well, I've been living here long enough. What factors do they look at?
So there's no specific time that you have to spend in Canada. Essentially, nothing stops you from submitting an application the very next day after your arrival, theoretically. But on practice, the longer you remain in Canada, the more you grow roots, right? The more you become established in Canada. And if you assess someone's situation, you have to put yourself in the officer's shoes. So you look at two people. One of them came a year ago and just found a job, maybe started making some friends, and yes, all factors in play. Every child would benefit from living in Canada compared to many other countries, right, out there. So it's not a question that Canada is among the top countries for life by the quality of life. But it doesn't mean that would be okay to allow every child essentially to remain in Canada, or to allow every applicant to remain in Canada, because some children might be affected. So here's the officer also looks at not only the factors that exist outside Canada, but as to how long did this person actually remain in Canada, and how tied he became to Canada. And so, for example, if you have a person who spent a year in Canada and you have a person who spent like 3-5 years, the person who spent more time in Canada obviously would have more roots. So they might have mortgage, they might have some loans, they might have a stable employment, they might have friends, they have volunteered, they have just, they build their life in Canada essentially from scratch, and this life is in full blossom right now. And if they are forced to move out of Canada, then they will have to start their life from scratch. One, they will lose everything that they've built in Canada. Two, and then there's no guarantee that they will actually succeed in building the same quality of life they've built in Canada. So everything again comes to play, and the officer doesn't look at specific time that you spent in here, but looks at the quality of life that you've built, looks at your involvement into Canadian society, looks at your contribution to the society, and so on. And so when we speak with our clients, one of the things that we always take into consideration is how long did they spend in Canada, how much time, and then what they've been doing during this time. Were they just going to work and back home and watching Netflix, or they were going to work, trying to make friends, volunteered, contributed to society, played any meaningful role that would make them a valuable members of Canadian society. And it's so much easier to pitch to the officer that, look, it's okay, we understand you may not be concerned by some of the factors that exist outside Canada, but think about this person and how much they contributed to our country. And if you would let them go, first they will lose everything that they've built, and then Canada will lose, because they are just so good for our country that it's in our best interest to keep them.
Yeah. And when we talk about, and we've mentioned before, unique and exceptional circumstances that just cry out for relief, I can't help but think of our current, one of our current clients that we just received the passport request to finalize and the H&C application. We're so excited for her, but she was in just a horrific situation with an abusive spouse in Canada. And when we talk about abuse, we're not talking just about, not that any abuse is acceptable, but we're not just talking about, verbal abuse or emotional abuse. Like, it was all forms, everything you could imagine, just horrific. And to the point where she was in a shelter ultimately when she contacted us. And as we slowly worked out the details and the circumstances and really learned her story, there was no doubt in my mind that her application was going to be approved. Canadian children, establishment in Canada, hardship, all of those factors all came into play. But in her situation, her unique situation was just so, so compelling, so in need of relief, that there was no way any officer out there was going to be refusing that application. And so every person is different. And that's why it is so important when you're choosing to hire someone to help you or you're choosing to file yourself, you're not going to go online and search and see what, the arguments are for H&Cs. You're not going to, go to a representative that just treats you like a number and just has a standard canned, template that they use for filing these. These applications are unique to you. And there should be an extensive discussion, many visits, many, individual consultations talking about your history. And then it's all compiled into a submission that, brings it all together and highlights the points that, that are going to be key for an officer when they're making these decisions. And that's probably a good lead in to the next section I want to talk about, Igor, which is the process. So what if you can kind of, in a short period of time here, talk about the process of preparing an H&C application and some of the things that you factor in, when you're trying to do this. How do you approach it?
Yeah. So, there are so many things to talk about, but I'll try. So first, everything starts with a consult. So we don't want to accept someone as a client for the H&C application not knowing about their situation. So to learn about the situation of the person, we need to actually talk. We need to see what's going on. Why do you even consider applying for the H&C? Or why maybe you did not consider apply for the H&C, but you should. So consult is step number one. Second, if we decide to work with our clients, we work in a collaborative review model. So typically, this would mean that the client prepares the draft of the applications, and then we review them, correct mistakes, make sure that everything is perfect, and only then the client submits the application. With the H&C, it doesn't work this way because of the level of lawyers' involvement and the importance of the submission that we must prepare. So it is still a collaborative process. So we cannot do our job without the client doing their job. And so the process looks something like this. We tell the client to write us a little book, right? So it has to be a little autobiography, starting with all of the circumstances in your life that you had from your childhood up until today, where you explain everything from how you became a person who you are right now, what factors and what life events shaped you, and what exactly happened to you that would be unacceptable by a fair-minded Canadian, essentially. So when I work with my clients, I typically ask them to write me 20, 30 pages, their own story in their own words, so that I have everything in writing. And then we review the story, and we are really cruel in reviewing the story. So essentially, we ask follow-up questions to every point that we think, there might be something else that could be included in here. For example, a client may say, I was raised in a family where my dad just left and my mom raised me since I was 5. And that would be the end of it, right? So we want to inquire, why did your dad leave? Was there any history of conflicts between your parents? Did you witness shouting? Did you witness family violence, domestic violence, right? What preceded your dad leaving? What happened after your dad left? Did you remain in contact with your dad? Did you have a stepfather? How did your mom afford to bring food for the table for both of you without another provider? So all of these factors are important. Even in like this one sentence, there are so many follow-up questions that we can ask, and we want to know everything, because you may not think about the impact that of your dad leaving the family when you were a child, but there was an impact. You may not realize it, but there might be an impact that, for example, now you look at the family, the concept of family a little bit different. Maybe you had some trauma, psychological trauma, that played out years later. And so we ask all of these follow-up questions, and clients provide us with additional responses. And then we analyze this story, and we start working on our own submission. So we explain the story in the language that would be easy for the officer to understand, and that focuses and presents arguments in a way that would make the submission more compelling. Then, as we work on preparing the letters, the submission letter, we ask our clients to collect evidence. So they want to collect reference letters, they want to collect any documentary evidence. For example, if that's a Ukrainian family and they have a house that was destroyed in Russian shelling, we want to see photos of that house if that's possible. Or we want to know, like, if there was a surgery, we want to see medical documents. Sometimes this evidence is not available, and that's okay. Not everything can be documented in evidence, but we want to see whatever you have. Next step would be to register for the visit to a psychologist. And sometimes it doesn't play out this way every time. Sometimes we don't go to psychologists. And for example, with our last client who just got approved in her H&C application, she was in real financial scrutiny, so we didn't have her go through a psychologist, and her situation was so harsh that would be an overkill if she would provide a psychological assessment. Even without the psychological assessment, you can understand that not a single person would endure what she did, what she endured.
And we had the criminal record reports, like we had
Mm-hmm.
the filings that went to with respect to the criminal matter, which laid out a lot of those details as well.
Yeah, but like in many cases, we do refer our clients to do a psychological assessment,
Mm-hmm.
and those psychological assessments are really helpful, because essentially they look at your past, they look at your present, and they look at how your removal from Canada will impact your psychological well-being. So, for example, you may have endured some hardship in your home country because of the war, for example. If you are forced to leave Canada and go back to Ukraine, for example, would that be a positive factor, or it would even produce more harm to your psychological well-being? Maybe you just started recovering here in Canada, and that would be so inhumane to send you back. So psychological assessment is another step that goes parallel to our drafting submissions. And then one thing that we also do is we provide we draft the affidavits with our clients. and we commission affidavits so that whatever the client says can be used as evidence in the file. Once
And
we
I'll
have
also
all
point
of
out
the
too, Igor,
yeah.
I'll also point out as well that it's not just the applicant necessarily that you're going to send to have an assessment. In the case of the family that the family that was struggling because the mother was just unable to care for the children, we actually had assessments done for the children. So there was reports on the impact of them on them if their father would have to leave. And so always consider all parties involved in the application, whether they're a principal applicant or not.
Yeah, and for the two cases that I've been working with Ukrainian nationals in the last half a year, one family was just a mother and a son, so both of them had their psychological assessment, and the other family had 4 family members, so all 4 of them had to go through the psychological assessment. Sometimes you would also have the psychological assessment of the person who is located outside Canada. If that is the family who you support, and that family, for example, has a child, and we keep coming back to the best interest of the child, maybe someone from that family can complete the psychological assessment and show that it would be just unbearable for them to survive, and that would cause a lot of psychological and emotional harm to them if you are forced to leave Canada. So once we have all of this, so once we have the evidence, the submission, the psychological assessment, the affidavits, it's a long process. Sometimes it may take anywhere from a couple of months to at least half a year, or sometimes even longer. Really depends on the situation. Then we get to filling out the forms. So unlike every other immigration programs where immigration forms are the center bone of the whole application, in H&C applications, forms are as well important, like no doubt. You cannot submit an application without sending any forms, but those are the least complicated part of the process. And it usually, forms can be completed within a couple of days only. So we always keep the forms to the very end. And another reason why is that forms also get updated from time to time, and we want to send the latest version of the form. So if it takes us 6 or 7 or 8 months to prepare the application, there is a good likelihood that the form might be outdated by the time when we send it. So we always keep that to the very end. And then when we submit an application,
we should also point out that our goal is to finish it in 2 weeks. Our goal is to finish it in 1 week. It's just sometimes things take more time, like booking an appointment with a psychologist, like collecting evidence from the home country. All of these factors that we put in, we just leave no stone unturned. And the burden is on the applicant to demonstrate the hardship, the establishment, the best interest of a child. And so as counsel, as lawyers, immigration lawyers, when we're helping our clients with these applications, our job is to take this massive amount of information. And Igor also alluded to the fact he likes 20, 25-page essays from clients. Well, it's the details. That's where the application really has its strengths. It's in the details. And so the more information we can get from our clients, the better able we are to compile it, to craft a cohesive narrative that ties all of these factors together. And we do all we can to present the case in a way that meets the Chirwa test. And from that case that Igor talked about. So we structure it in a way that highlights the factors that the officer, it makes it easy as possible for them to say, okay, yep, that factor's there. Yep, that factor's there. Okay, there's enough. Versus just this one steady stream of an essay with no headings, no breaks, no organizational structure. So the form of how you structure it can be just as important as the content itself. So, when you think about risks, Igor, the risks of an incomplete or poorly prepared application can literally mean the difference between an approval and a rejection. And these officers have time to look at the applications. But still, if we can organize the material and explain it in as clear and concise a manner, and well, I say concise because you don't necessarily want a submission that's 40 or 50 pages. If you can make it concise and to the point and make it 15, the reality is it's different by individuals. But let's just shift, Igor, as the time is quickly passing. Let's just shift to some of the challenges and common pitfalls. So where do you see problems arise the most for people? Whether they're trying to do it themselves or, after people have gotten refusals even. What are some of the challenges and pitfalls they face?
So one of the challenge is people just underestimate the complexity of the H&C application. They think, I'm just going to tell them my autobiography and say that I have met I have 3 factors in my application, check, check, check. And then the officer will look, think, okay, yes, best interest of the child is affected. Yes, there is a war in the country, so adverse country conditions, and there's no explanation needed. So that's their biggest misconception. And the reason why we ask for 25, 30 pages submission from the clients sometimes is because we want to know the details and we want to present those details and arguments to the officer in an efficient way. And it takes practice. And every H&C submission essentially gets better and better, but not a single case is the same as the one before it. And so it's just this art of presenting the information to the officer in the right way. And unless you have practice and skill and writing skill and experience doing it, it's really hard to present this information to the officer in the right way. So one of the experience that I recently had, I had a consultation with the family, and they informed me that they want to apply for the H&C. And I asked them if they can share their screen and show their submission just briefly. And they had like 3 pages submission. Probably no need to say that would not be sufficient to succeed, regardless of how well they filled out their immigration forms. And so underestimating the complexity is the biggest challenge. Next is people try to apply for the H&C as soon as they come to Canada. And again, we've talked about establishment. You want to be established. You want to spend sufficient time and build sufficient ties with the country so that your removal would disrupt your whole life. And you want to explain that to the officer. Look, it just, like, I'll have to start my whole life from scratch. I don't have any ties with my home country. Essentially, you just depriving me from everything that I've built in here. And then another thing that I see sometimes is that people apply for the H&C just and treat H&C as a loophole, as a backdoor to permanent residence. So sometimes they would say, I just don't know English very well, and I don't think I can qualify for the provincial nominee program. In this scenario, they consider H&C because there is no minimum language requirements for the H&C. Our response typically is not something that our clients like to hear, and we say that the H&C is not something that they should be seriously considering, at least right now, unless like very pressing circumstances exist. Because for the H&C, and one thing of the establishment is your ability to provide yourself financially. And how can you do that without language? How can you establish yourself in Canada without language? You want to demonstrate that you actually try to learn English or French. You try to integrate into the labor force, into the society, and without language, that's impossible to do. So it's not another second option for you just in case the PNP doesn't work, or you don't want to invest your time in learning the language. Invest the time, try to meet the requirements of the programs that are available out there, And only if you are ineligible and there is no way that you can qualify for any of the programs, then consider the H&C. And in fact, this ineligibility for the regular immigration programs is another thing that the officer seriously look at. They always want to make sure that the H&C is not used as a backdoor. So you have to demonstrate why you are not eligible for any of the standard programs, whether that PNP or federal immigration programs. Because unless you do it, the officer will have the assumption that, oh, this person just doesn't want to, I don't know, improve their language or find stable employment, or this person didn't do whatever it takes to qualify for the immigration programs that exist. And that's why they use H&C, just because there are no minimum requirements.
Right. And it's important to point out that filing an H&C does not confer any status on you. So you still have to have the ability to stay in Canada and to extend your temporary stay while the H&C application is being processed. So it doesn't prevent, even if you fall out of status in the Canada Border Service Agency, from removing you if you have an H&C application in the queue. So keep that in mind. And as we move forward and we think a little bit more about the actual decision-making process of an officer, they're looking at this Turbo test, right? Would a reasonable, fair-minded Canadian find it acceptable to deny relief? So the importance of fairness, compassion, and a holistic approach is really what they're looking at. So our job as immigration lawyers is to frame the submission in a way that makes it as easy as possible for the officer to see that there is this need for relief, and so yeah, it's not an easy job. It's probably some of the most difficult applications for an officer to adjudicate, because you can't use artificial intelligence to streamline applications. You can't use it to or any level of triaging or otherwise to reduce the load that officers go through. You can't use automation. This is something where an officer has to just put their head down. They have to read the material. They have to assess it. And so the job is to make the officer's adjudication process as streamlined and easy as possible, and to point them to the natural response, which is approval. So keep that in mind as you're going forward with your H&C applications. And then finally, Igor, do you have any last closing kind of remarks or takeaways as we wrap up this section on humanitarian and compassionate applications?
Yeah, I would. My probably the biggest comment would be, don't try it on yourself without any professional help, because the consequences of a failed H&C application might be extreme. So by the time when you receive the decision, you may already be out of status with all of the complications that stem from there. Another comment would be, don't underestimate the complexity of this process, and don't treat H&C as just another program that may get you permanent residence that doesn't have the strict requirements that you normally see in PNPs and federal immigration programs. From all of the immigration applications that we make, I would place H&C in the top maybe 2 or 1 in terms of how complicated they are. And they are not profitable for sure. I can imagine that some maybe law firms or immigration consultants can make a good profit out of it. I would imagine that some people would charge $40,000 easily for the H&C application. We don't do it. So our fees, at least at this time right now, start from $7,000, and the price can fluctuate. Sometimes we do pro bono H&C applications, where we just cannot help but just take on the file and do everything in our power to help a person stay. And we've done it over the last 5 years.
Yeah, Igor,
a lot of applications.
It seemed like it's kind of it's kind of a 1 to 2 ratio, doing it pro bono or otherwise. And you think of that poor woman who was in that horribly abusive situation. Like, it was our pleasure to help her, for free. And it's really becomes more a labor of love than it does a money-making venture. But we just see so many people out there right now that are are just being exploited and taken advantage of. And some of the best advice that we can ever give our clients is no, you do not qualify for H&C. You do not have a case for H&C. And, that isn't always what people want to hear, but we pride ourselves in being honest and encouraging people to explore all pathways that they are legitimately qualified for, and not, abuse the process by filing applications that really have no merit. So I want to
I can easily see how you can make a good living preparing H&C applications. Every client who comes to you right now in this desperate time, in this very dark time in immigration to Canada in 2024, and they say, I don't have any option. Like maybe H&C is my last resort. Can you take my file? And if you would say yes to every single person and charge them $7,000, oh my God, you can be rich very quick. But in reality, from 10 people who consider H&C and who book consults, I would confidently say we may take 1 or 2, because it's not every person who has the circumstances that would merit relief, right? And so we have to be critical, and sometimes we have to say yes, not something that the clients want to hear, but at least we can sleep easy at night knowing that we didn't charge people money that they would otherwise spend on something more important and something more workable than the H&C.
Such as preparing to go home and using that money to help get reestablished in home. All right. Thank you, everybody, so much for tuning in to this episode. I think this is one that many, many people really need to listen to and understand. We encourage you to share it with others. If you're watching it here on YouTube, if you're listening to the podcast episode, please share it and leave a comment, leave a review. We love to engage with you. And if you ever need assistance, you can just slide over to holthelaw.com, and there's a consultation booking, and that's how the process starts. And I just want to wrap up once again with head over, once you've heard this, go to the H&C and Humanitarian Compassion Applications. A Lifeline for those without options, this blog post that Igor put together, and it's on our website. You do not want to leave without reading that blog post, because there's a whole bunch more detail in there. All right, Igor, thanks so much. And thank you, everyone. Take care.